There is an island nation in the South Pacific, a place with fewer than 20,000 permanent residents, whose courts have done something no American court has ever successfully reversed. They looked at an order from a United States federal judge, an order commanding the release of assets held in a trust within their jurisdiction, and they said no. The Cook Islands Trust Act, enacted in 1989 and strengthened through subsequent amendments, explicitly prohibits Cook Islands courts from enforcing foreign judgments against assets held in a properly structured Cook Islands International Trust. The American judge has no enforcement mechanism. The American creditor has no recourse. The assets sit, legally, safely, and completely beyond the reach of the most powerful legal system on earth. The American plaintiff can win every court battle in the United States, and they still cannot touch a dollar of what is held in that trust. This is not theoretical. In the 1990s and 2000s, a series of high-profile cases established the Cook Islands as the most creditor-resistant trust jurisdiction in the world. In Anderson, 5 United States, American courts ordered a debtor to repatriate assets held in a Cook Islands trust. The debtor argued that they were unable to comply because the trustee, operating under Cook Islands law, was required to refuse repatriation in response to the order. The American court held the debtor in contempt, but the assets never moved. They remained in the Cook Islands, intact, protected by a legal system that had specifically designed its trust laws to resist exactly this type of pressure. The creditors received nothing. The contempt citation achieved nothing. The trust held. Welcome to the invisible ledger. If these stories matter to you, hit subscribe and the bell. This is where we trace the money they told you not to follow. The Cook Islands are a self-governing nation in free association with New Zealand, located approximately 3,000 kilometers northeast of New Zealand in the South Pacific. They have a population of under 20,000 people, a GDP driven primarily by tourism and financial services, and one of the most sophisticated asset protection trust industries in the world. The International Trusts Act of 1984, significantly strengthened in 1989 and repeatedly amended since, created a legal framework for offshore trusts that was designed from the ground up with one primary purpose: making it as difficult as possible for foreign creditors to reach assets held within Cook Islands structures. The specific legal features that make Cook Islands trusts uniquely powerful include several provisions that no American domestic trust can replicate. First, the statute of limitations for fraudulent transfer claims in the Cook Islands is the shorter of 2 years from the date of the transfer, or 1 year from when the creditor discovered or could have discovered the transfer. This is dramatically shorter than the 4 to 6 year look-back periods that apply to domestic trusts under American law. Second, a creditor who wishes to challenge a Cook Islands trust must bring their claim in Cook Islands court. No foreign court order is enforceable against a Cook Islands trust. The creditor cannot simply take a New York judgment and present it to a Cook Islands court for enforcement. They must start fresh in a foreign jurisdiction under Cook Islands law with a legal system specifically designed to make their claim difficult to succeed. Third, the standard of proof for a fraudulent transfer claim in the Cook Islands is beyond a reasonable doubt the criminal standard, rather than the preponderance of the evidence standard that applies in American civil courts. This near-impossible evidentiary burden makes successfully challenging a Cook Islands trust extraordinarily difficult, even for well-resourced plaintiffs. The practical result is a financial fortress. Assets contributed to a Cook Islands trust before any legal dispute arises are essentially judgment-proof, not theoretically difficult to reach, actually unreachable through any legal mechanism available in the United States. Before I go further, this video is just the surface. Inside the Invisible Ledger Vault, you will find the complete Cook Islands Trust Formation Guide, the trustee selection criteria and licensed trust company directory, the fraudulent transfer timing analysis, the reporting requirements under FBAR and FATCA, and the case study analysis of Anderson v. United States and subsequent Cook Islands trust litigation. The link is in the description, but stay right here. The structure of a Cook Islands trust typically involves several components. The settlor, meaning the person establishing the trust and contributing assets, is usually the person seeking asset protection. The trustee must be a licensed Cook Islands trust company. There are approximately 40 licensed trust companies operating in the Cook Islands, including Cook Islands Trust Corporation, Pacific Trust Group, and similar institutions. The trust is irrevocable in the sense that the settlor relinquishes legal control of the assets, though in practice, a carefully drafted trust deed can preserve significant influence over the trust's investment decisions and distribution policies through a trust protector mechanism or a letter of wishes. The trust protector is a third party, often a trusted advisor, who has the authority to remove and replace the trustee, modify certain trust terms, and exercise specific powers specified in the trust deed. This allows the settlor to maintain meaningful oversight without retaining legal control that would undermine the asset protection. The assets held in a Cook Islands trust are typically cash and marketable securities held in accounts at international banks in New Zealand, Switzerland, or other stable financial jurisdictions, with the Cook Islands Trust as the account holder. Real estate within the United States cannot typically be held directly in the trust because it remains subject to American courts' jurisdiction over the property itself. The strategy is most effective for liquid financial assets. The compliance burden for American citizens using Cook Islands trusts is substantial and non-negotiable. The United States taxes its citizens on worldwide income regardless of where assets are held. An American citizen with a Cook Islands trust must file FinCEN Form 114, commonly known as FBAR, the Foreign Bank Account Report, for any foreign financial account exceeding $10,000 at any point during the year. They must file IRS Form 8938, the Statement of Specified Foreign Financial Assets, under the Foreign Account Tax Compliance Act, if the aggregate value of foreign financial assets exceeds specified thresholds. They must file IRS Form 3520 to report transactions with foreign trusts, and the trust itself may need to file IRS Form 3520A. As a foreign trust with an American owner, these filing obligations are strictly enforced. Failure to file FBR carries penalties of up to $10,000 per violation for non-willful failures, and the greater of $100,000 or 50% of the account balance for willful failures. If you have made it this far, you understand the Cook Islands Trust at a level that most American asset protection attorneys charge thousands of dollars in consultation fees to explain. Subscribe and share this video. The establishment cost of a Cook Islands Trust is significant. Initial legal fees for drafting a properly structured trust deed, selecting a trustee, and managing the compliance documentation range from $15,000 to $50,000 depending on the complexity of the structure and the attorneys involved. Annual trustee fees typically range from $3,000 to $10,000 or more. Annual compliance costs for the required IRS and FinCEN filings add additional professional fees. An ongoing legal review to ensure the structure remains compliant with evolving FATCA and FBAR regulations adds further cost. In total, the annual carrying cost of a Cook Islands trust is typically between $5,000 and $20,000. The break-even analysis is straightforward. If you face potential legal judgments measured in hundreds of thousands or millions of dollars, the cost of protection is trivial. If your asset exposure is modest, the costs may not justify the structure. Cook Islands trusts are most commonly used by physicians, dentists, and other healthcare professionals who face malpractice exposure, by business owners in litigation-intensive industries, by real estate developers with significant personal guarantees, and by high net worth individuals seeking to protect liquid wealth from future creditor claims. Now let me give you the practical steps. Step 1. Consult with an asset protection attorney who specializes in offshore trusts. The Cook Islands Trust is not a do-it-yourself structure. The legal precision of the trust deed, the trustee selection, and the compliance framework are all critical. Step 2. Select a licensed Cook Islands trustee. Your attorney can provide referrals to reputable licensed trust companies. The trustee must be Cook Islands based and licensed under the Cook Islands Trustee Companies Act. Step 3. Draft the trust deed carefully with attention to the trust protector mechanism, the distribution standards, the investment powers, and the anti-duress clause. The anti-duress clause is particularly important. It instructs the trustee to automatically shift assets to a secondary jurisdiction if the settlor is under legal compulsion, such as a court order, to instruct repatriation of assets. This is the mechanism that makes the trust self-protecting. Step 4. Fund the trust. Transfer liquid financial assets into a bank account established in the trust's name. Timing is critical. Assets must be transferred before any legal dispute arises. Transfers made after a dispute is foreseeable are potential fraudulent transfers under both American and Cook Islands law. Step 5. Establish and maintain all required IRS and FinCEN reporting. Work with a CPA who has international tax experience to ensure all forms are filed correctly and on time. Step 6. Review the trust annually with your attorney. The Cook Islands trust legislation, IRS regulations, and FATCA requirements evolve. Annual review ensures the structure remains optimally configured. I need to be honest with you. The Cook Islands Trust is the most powerful asset protection tool available under current law, but it carries real risks and limitations. First, the contempt of court risk is real. An American judge who orders you to repatriate assets and fines you in contempt has real enforcement tools, including incarceration, as American debtors have discovered. The trust protects the assets, but not necessarily the person. Second, the IRS compliance burden is substantial, and the penalties for non-compliance are severe. This structure must be operated with meticulous compliance to avoid creating tax problems that dwarf the creditor problems it was designed to solve. Third, the fraudulent transfer risk exists under Cook Islands law as well. Assets transferred after a dispute is foreseeable can be challenged even under the more restrictive Cook Islands standard. Fourth, these structures have been used for tax evasion by some users, and the IRS scrutinizes them intensely. Legitimate use requires full disclosure and compliance. Fifth, political and regulatory risk is real. The Cook Islands could change its trust laws, or international pressure under FATCA and the Common Reporting Standard could reduce the practical effectiveness of the structure over time. Your grandparents, who emigrated to America, carried everything they owned in a single suitcase. They understood that what a government could not see, it could not take. For generations, the wealthy families of every era found ways to put distance between their assets and the legal reach of any single jurisdiction. The Cook Islands Trust is the modern, legally refined, fully disclosed version of that instinct. It does not hide assets from the IRS. It does not conceal income. It files every required form and pays every required tax. It simply places assets in a jurisdiction where foreign court orders cannot follow. There was not a more elaborate system. There was just a more honest version of the oldest principle in wealth preservation: distance protects. Subscribe and share this video. Every share puts the Cook Islands Trust on the radar of someone who is one lawsuit away from losing everything they built. The next vault opens soon, and what is inside will show you how to pay off a 30-year mortgage in 5 years, using a financial mechanism that almost no bank will explain to you and that virtually every mortgage holder could use. Exact.